All set. Mr. Mora, you've heard that what happened at Guantanamo did not constitute abuse of detainees. Do you agree with that?
Sir, I think abuse occurred, and potentially even torture of some detainees.
And in terms of what was authorized by the Secretary, do you believe that that constituted abuse? In other words, what he said was okay, those Category 2 and some of the Category 3 techniques that he approved on December 2nd. In your judgment, were those abuses permissible under Geneva or under other law?
Senator, it depends upon how those techniques would be applied.
Just how about nakedness? Nudity, would that be permitted?
I think it would not be permitted, General.
How about use of dogs to induce stress?
It would not be permitted under Geneva.
All right, now, Admiral Dalton, I think you said that I believe that you said that part of the reason that you understood that was the reason why you were told to stop your legal review was because Mr. Haynes did not want the service's critical comments disseminated. Is that correct?
Senator, I don't recall if those were my exact words. I believe that...
Is that one of the reasons?
I believe that I understood that Mr. Haynes did not want broad-based discussions of this topic and of these issues and dissemination of various memos and memoranda and that sort of thing.
All right. Now, did you see the memorandum from the various services objecting to these techniques? Did you read those memoranda?
Yes, Senator.
Those memorandum came before the decision of the Secretary of Defense on December 2nd. Is that correct?
That's correct.
Because I think it's very important, and this is really what is one of the things that is new here this morning, is that the protests, the objections of the military, the JAG officers in the services came both before and after the December 2nd, 2002 memorandum. Is that correct? In other words, when that task force was appointed later on, there were some objections. Mr. Mora was involved in those. But prior to December 2nd, prior to the Secretary of Defense signing that Category 2 and some Category 3 techniques were going to be authorized, the military JAG officers and the military lawyers objected strongly to the recommendation that came from Gitmo. Is that correct?
Senator, the memos were not all written by JAG officers. They came from the staff planners, generally with input from some of the JAG officers.
Fine. They came from the services.
From the services, fine. Yes, Senator. And while they raised serious concerns about the use of particularly the Category 3 techniques, they also identified the need for valuable intelligence and suggested that there should be further legal and policy review.
Of course. And that legal and policy review you were undertaking until you were stopped. Is that correct?
Yes, sir.
So that didn't occur the way they recommended.
The broad-based legal and policy reviews, such as the one that took place later, January to April of 2003, did not occur.
And that's what you were told you were supposed to do until you were stopped.
Senator, that's what I took upon myself to do.
Well, weren't you asked to give a legal analysis by the Chairman of the Joint Chiefs?
Senator, that was a part of my job. I didn't have to be asked. I understood that there was a requirement for a legal and policy review, and I initiated such.
Right. Now let's take a look at some of those objections from the Army. Army interposes significant policy and practical concerns regarding most of Category 2, not just Category 3. Category 2 and all of Category 3 techniques proposed. The International Operational Law Division of the Army, the chief, said that the stress positions, deprivation of light and auditory stimuli, and use of phobias to induce stress, quote, crosses the line of humane treatment and will likely be considered maltreatment under the Uniform Code of Military Justice and may violate the torture statute. That trouble you when you read that? Were you troubled when you read that?
Senator, yes, Senator, I recognize that there were concerns, absolutely.
I'm asking you whether you're troubled. Is the answer yes?
I'm not sure.
Were you troubled that there was a request to authorize the treatment of detainees, which in the judgment of lawyers and the judgment of the military said, that their judgment, that, case of now the Chief of the Army's International Operational Law Division, stress positions, deprivation of light, use of phobias to induce stress crosses the line of humane treatment, would likely be considered maltreatment under the Uniform Code. Were you troubled that you were being requested, that
Senator,
Secretary of Defense was being requested to approve something which, in the judgment of that Chief of the Army's International Operational Division, would do that? Was that troubling to you? Did it cause you concern?
Senator, those comments were made by the Army, in this case, the International Law Division, without a complete analysis being done. It was the initial response from the service that occurred, that came to the Joint Staff within 2 or 3 or 4 days after the initial tasker went to them.
Right.
It certainly was of concern. My own office had concerns. I had concerns when we saw the request come in. However, I felt that we owed it to the combatant commander to do a full and complete review and not to simply turn around and deny the request.
Of course.
The initial responses from the services indicated that there were concerns, and that's what I took them for.
And you were stopped right in the middle of that review. Is that correct?
I was stopped from
the review you were conducting. You were stopped in the middle of the review you were conducting.
Of coordinating with the services and engaging other agencies to come in.
That's the review you were conducting?
Yes, sir.
And you were stopped in the middle? Or was it the beginning? Or was it the 2/3 through? You were stopped during that review from finishing it. Isn't that correct?
Yes, sir.
Why is that so hard to say yes if you were?
Because I want to be very clear that what I was stopped from doing was engaging in a broad and open discussion with all of the services. That does not mean that I completely divorced myself from the process. I continued to work with Mr. Haynes in his office. My staff continued to work with Mr. Haynes in his office.
You were stopped from doing what you thought was appropriate you should be doing. How's that?
I was stopped from conducting the broad-based review that I had intended to conduct, Senator.
Which you thought was an appropriate review?
Yes, sir.
Okay. Now, in terms of the dog that was there, I don't know who was it? The purpose of the dog. I think it was you, Admiral. It said it was the purpose of the dog. What was the purpose of the request for the use of a dog? I think it was you, Admiral, who said it wasn't to scare, or something else, or was that you, Colonel Beaver?
Well, from the perspective at Gitmo, it was explained to me that that the purpose of the dog, it could be used as perimeter security, which would be fine, and that if that unsettled the detainee, then it would work a dual purpose, because part of interrogation is to keep you unsettled, is to, when you play the mental chess game. So when I asked about the dog, because I am a former military police officer before I was an attorney, I know that you don't take dogs into a detention cell or any other kind of cell or whatever, and I was assured that that would not happen. I found out after I left Guantanamo during the Schmidt furlough investigation that it had happened on one occasion. I was unaware of that at the time.